because throughout the section, it mentions the Governor General, after consultation with the Prime Minister and Leader of Opposition, sir.
Yes.
Yes. But I noticed at subsection 5 that it only speaks to the Governor General taking certain actions without any consultation, and I wonder whether that was the intent or whether it's an oversight.
No. Well, the Governor General makes his determination further to the tribunal, and the tribunal will be the tribunal which is consisting of individuals who have held office as a judge of a court having unlimited jurisdiction in civil and criminal matters in the Commonwealth. And so that tribunal will be fitted with persons of sufficiency who would advise the Governor General. Yes.
Amendment to clause 16. Those in favor?
Aye.
Against? Ayes have it. I put clause 16 as amended. Those in favor?
Aye.
Against? Ayes have it. Clause 17.
There's no proposed amendment to clause 17.
So I put clause 17. Those in favor?
Aye.
Against? Ayes have it. There are amendments to clause 18 contained on page 5, I believe.
Or 4 of the new list. Yes, the substitution of subclause 1.
I put the amendment proposed.
Chairman, I'm seeing on subsection 2, he may, after constitution, I believe that should be consultation.
Where is that?
So, the third line in 2, after consultation, it should be consultation with committee, appoint an officer of the agency.
Okay, no, the editorial is no.
Editorial.
Yeah, okay. So I put the amendment to clause 18. Those in favor?
Aye.
Against? Ayes have it. I put clause 18 as amended. Those in favor?
Aye.
Against? The ayes have it. Clause 19, there is no proposed amendment, so I put clause 19. Those in favor?
Aye.
Before, President,
Sorry, 1 minute.
I just want to be clear that what it is said here, saying here, is that the DPP retains his or her power under Section 94 to intervene in any prosecution and to stop it. That's what is being retained. Just want to be clear.
Well, it would never supersede the constitutional power.
So the DPP can intervene and
That's
stop
a constitution. That's from the Constitution.
it. And with that, I have no problem. I just want to.
Thank you, Senator Brown. I put clause 19. I'm sorry. Yes, clause 19. Those in favor?
Aye.
Against? Ayes have it. Clause 20, there's no amendment, and I put the clause. Those in favor?
Aye.
Against? Ayes have it. Likewise, no amendment to clause 21. Those in favor?
Aye.
Against? The ayes have it. Clause 22.
There's an amendment.
Seems to be a renumbering issue.
Yeah, there's a proposed amendment to delete subclauses 2, 3, and 4 of 22. And this, Mr. Chairman, arises from some of the concerns that were raised at the last sitting regarding the borrowing powers of the agency. Now, this agency is a body corporate. It retains body corporate status, and so as per Section 28 of the Interpretation Act, it is unnecessary for us to put these subclauses because within that context, it already has those borrowing powers. So we have removed subclause 2, 3, and 4.
Thank you. So
No concern about this now. Body power, body corporate or not. Right? It is, as I understood it in the title of the bill, it says it's an agency of the government.
Yes.
And I understand the financial regulations requires that the ability to borrow money is subject to the approval of the Minister of Finance. And what I sense in the clause before you remove them, and which might have worsened the situation, is that they had unlimited power to borrow without any control. And I think that this may be in conflict with the existing financial responsibility legislations.
You mean it may have been? What we have removed would remove the concerns that you had. It was based on those concerns that we removed it. And so it would fall to the ordinary body corporate status that is arisen from Section 28 of the Interpretation Act and any obligations that flow from that. So you would not have the ambiguity which was there before as you defined it.
No, my concern as a citizen of this country is under whatever name we do is not to give government agencies the power to borrow money, run up the national debt without approval from the elected Minister of Finance. And I'm not sure if what you're doing removes that or reaffirms that no government agent, no matter how described, can borrow money without the approval of the Ministry of Finance. And that's what I want to be clear and satisfied that that is, we're going to do it properly.
Well, I don't think there is anything that suggests that it is or would be done properly. It falls within the usual obligations that arise from a body corporate status definition in our Interpretation Act. So my understanding is that any obligation that flows from that would be attached to this. If you want, what I could do, Mr. Chairman, is ask for clarification, and we could move on to another clause and recommit this.
Mr. Brown, you want further clarification on it? Okay.
Thank you, Mr. President.
No problem.
I like that mood that you're in.
As I say, I understand why Mr. Skeffrey might be a bit. But you want me to apologize? Senator Skeffrey, I apologize to you. I understand why you might be in a bit of a fractious. I understand why you might be in a bit of a fractious mood. Who wouldn't be? Let's go. So we're going to recommit section 22.
22.
So I will deal with 23.
23, there's a proposed amendment to clause 23, Mr. Chairman, and that is simply for us to add a subclause 4 following subclause 3, which introduces the Auditor General, which at the last instance it has been expressed that the Auditor General had been omitted from performing a function under the bill. And
yeah,
so
I remember that. So I put the amendment to clause 23. Those in favor?
Aye.
Against? Ayes have it. I put clause 23 as amended. Those in favor?
Aye.
Against? Clause 24.
You can take it straight up from 24 to clause 30, Mr. Chairman.
I can't do that without agreement from everybody. Is everybody agreed to that?
Yes, no.
24 to where?
24 to clause 30, there are no amendments, and there were no issues.
Okay, so I put clauses.
There's one, take it up to 29.
Okay, so I put clauses 24 to 29. Those in favor?
Aye.
Against? Ayes have it.
No, sorry, 29. In subsection 3.
You want me,
recommit, please.
So okay, so let me take 24 to 28. Those in favor?
Aye.
Against? Ayes have it. I recommit clause 29. Those in favor?
Aye.
Good. Thank you, Senator.
Subsection 3, 29, subsection 3. As I noticed that there's no timeline when the minister should present the report to Parliament, both houses. So there's a timeline when it should be presented to him, but he has no timeline to present it to the people through the Parliament.
Minister, you have a comment on that?
I crave your indulgence, Mr. Chairman. I'm considering what...
It would seem to me that if you put a time on it, it wouldn't be an issue.
President, I see the value of having a timeline, but there is certain exigencies in the system that makes it difficult, it appears to me, to comply with. And are we setting up an illegality even before the bill is passed? I understand the spirit of it, but I don't think it should be done.
Mr. President, Chair, probably for the Senator does probably elaborate more why you think it shouldn't be done. You understand, but don't think. I just probably want to know why. Yeah, and there's always mechanism that if it's not done with the time, you get validation and you seek permission to delay. But at least if we're talking about accountability, we only measure accountability by a timeline which is for efficiency. And if you can't, the Parliament will understand and justify.
Mr. Chairman, perhaps it would be prudent, considering both prospects that has been presented, for the technical team to take some time to look at the matter. If we could proceed, and we'll return to it, so that I can properly consider what Senator Skeffrey has suggested.
President, the item I have at 30 is at 34. It's along the same line. So if they want to look at 34, which has a specific thing, because my question is going to be, what if there's a failing? So maybe you want to look at
exactly, and it was raised by.
All right. So we're going to move on from 29, and we'll recommit 29. So
yes, and 30.
And 30.
Yes. So
okay.
we'll move to.
I thought you had said 30.
30 subsection 4. Yes. So if we could move on to clause 31, in which the proposed amendment is very clear. In this proposed amendment, Mr. Chairman, it gives effect so that the Director General cannot decline to facilitate the exchange of information between strategic partners or law enforcement agencies on the basis that they have failed to make a contribution towards the cost of exchange. And that was a concern raised, I believe, on more than just one side. And this is, of course, precipitated on those comments. So we'll put the proposed amendment to clause 31.
No, before I get to that, Chairman, I'm concerned, Chairman, and I'm sure my friends on the other side will support me on 31(1). As it is now, any contract, MOU, or other agreement or arrangement may be entered in with strategic partners, but there's nothing in 31 which requires that such an agreement can be kept at a park camp or should be disclosed to the public of the country. And I want to be clear that that's not what they intend, because they are on record of being opposed to such MOUs being confidential and kept at a camp. So I am wondering if there is a omission somewhere here for these agreements, these secret agreements, to be revealed to the public.
Senator Brown is a brave man.
Mr. President, really?
Where the hiding place, I hope.
No, that's clear.
Minister, you have a comment?
Clearly not the intent, Mr. Chairman, but if we could put the proposed amendment.
Sorry, I didn't hear what you said, Minister.
You're asking me to respond as to whether the government is intended to have secret agreements?
The question is whether or not it is intended that these agreements, which at this point under 31(1) appears to be secretive, are going to be open to disclosure to the public. For example, is there going to be a time limit which says after 5 years they may be disclosed, after 10 years, after 30 years they may be disclosed? Because it appeared to me these agreements relating to 30 issues which could include security corporations. And I have in mind the criticism of the Anthem Agreement, whether or not what this legislation is doing is reinforcing that approach, an approach which some believe was correctly entered into and kept the way it was kept. So I just want to make sure that what is being said here is to reaffirm the approach taken in the past and not now to move to a new position which says it is open to the public.
Minister, you intend to make any change to this?
No.
Senator Brown, you intend to make a formal
I don't think there's not much that gives any rise.
So
Mr. President?
If there was, Mr. Chairman, I think that in the spirit of how I have sought to proceed, that if there were any substantive issues of concern, I would certainly address them.
Thank you very much.
Mr. President, I'm satisfied that it is the government's intention, and they have my support, to continue the practice of the past.
So I don't know, that completely fly over my head, but that's all right. I put the amendment to 31. I put the amendment to 31. Those in favor?
Aye.
Against? I put section 31 as amended. Section 32, there is an amendment proposed on page 5.
Yes, just the substitution of a word.
Right, I see that.
Mr. Chair, on 32D, and set clause 32D, I see the various members, 3D, I see the various members that can be appointed to the oversight committee, and these are all persons that have specific skill set. But I believe any committee like this would need someone from civil society, more so a human rights group, to ensure we have the balance and fair play. So I'm propose that we said 2 members, so perhaps 3 members, or say 2 members and of another addition 4, and a member from civil society or human rights group, so as to ensure at all times we protect the rights of our citizens when we have to move to investigate them.
President, Chairman, at 5, sorry, you went?
No, go ahead.
At 5, Mr. Chairman, I would like to propose at 5A the similar proposal I made at 13(1)A, which is it should have a limit on 5 years for those who sat in the Senate, the House, and candidate. That's same amendment. That notwithstanding, they rejected at 13. I'm putting it back again at
Okay. And
13.
Senator Scarfer, you wanted to add, you are proposing to D to add a member of a, how you phrase that? Phrase it for me, Senator.
May I oppose it?
But you can oppose it in due course. You want to say something on it? You want to say something on it?
I have difficulty sometimes when you appoint persons from interest groups. When they go on these boards and committees, they tend not to bring an overall view to their responsibility, but take on just a charge that they are representing this group, and that is their agenda. And it can be inimical to the committee. I think we should appoint people that have the necessary broad width of knowledge and information that can do a job completely. So whenever it is put, I intend to oppose it.
Sir, Chairman, can I add to that? Because Senator Scarfer, I tend to agree with Senator Brown. If you look at 32(4), where it speaks about a person shall be eligible to be appointed as a member of the committee, and it goes on to talk about person of integrity, etc., diligence. I would think that would cover your concern in terms of somebody from civil society. I don't think we should be specific about any interest group. What is that? No. Look at 4.
No, Mr. President, am I hearing?
I would think that would cover your concern.
Mr. Chairman, am I hearing Senator Webby in adopting the argument of Senator Braham that D, 32D, 32.3D should be deleted because it addresses specific sector, financial sector, anti-corruption, public procurement. These are interest groups. So it just shows, it goes to show,
they are bringing us.
Let me finish. It
They are bringing a specific skill set.
It goes to show a lack of consistency in policy formulation. Because if we are saying human rights and other sectors like those should be excluded, on what basis do we include anti-corruption?
No, I disagree with you. The financial sector, anti-corruption and public procurement is a specific skill set that they want on the committee.
Human rights is not a specific skill set?
No, I won't.
Hello?
Mr. President.
Hello?
Thank you very much.
Chairman, I want to speak.
So the person, item 4 could or could not be some special interest.
Chairman.
Thank you very much. Thank you. Hello. Hello. I'm going to make Mr. Hill speak, and then you can speak, Senator Scott.
Mr. Chairman, thank you. I would strongly agree that someone from the financial sector, somebody from anti-corruption, somebody from public procurement, particular specific skill sets. I am very wary of unelected NGOs who have a particular agenda to be elevated to be public servants just because they or I might have a particular NGO agenda and inclination. And so we have to be very wary of that because
Mr. Brown, hold on a man.
You are going to let me finish. I said all NGOs do not get any specific elevation because I might choose to have a particular NGO. I should not be given that. I can go and make my case in the public square, but I shouldn't be elected. And Mr. Brown, Senator Brown, that's my opinion, if you don't mind. So hear me out now. I heard you out. So I'm saying I support specific skill sets, but not drawing people from areas of NGOs that have particular and narrow agendas. That's my point.
Thank you very much.
Mr. Chairman.
Oh, sorry. Go ahead.
Yes, I think we're all being very strongly supportive today. But I have to support the position of Senator Skeffrey because if one looks, for example, at 32 subsection 2B and look that the objective of the committee is to provide independent oversight in relation to the handling of complaints, then it is my position that when one looks at the composition of the committee, everyone here, to a large extent, brings to the table some kind of support in terms of the execution of the complaint that comes in. But there's no one there on the committee. There's no one there on the committee that is tasked with ensuring that there's a balance in the operation of it. And I think that is where the human rights person comes in. And I wondered, Minister, if it is that there may be some challenge and I can appreciate the concern in terms of how do you define a human rights group, then what is without question is the role of the public defender. And I wondered whether you would find favor in inserting that a committee member should be drawn from the office of the public defender, if not the public defender herself or himself.
Chairman.
Yes, Mr. Charles.
Let me just.
Thank you very much. So we hear. There are those who oppose it, those who are in agreement with it, and that is why the standing order said that we said it. You want to say something, Senator? Go ahead.
I'm reviewing, and I'm a little confused. It says 2 members appointed, nominated by the minister responsible for national security. I am confused as to why it has to be constrained to the areas that they have to be from. The Minister of National Security should, within his purview, feel it important for certain things to be appointed. Why is it that we have to have a financial sector or anti-corruption or public procurement? In particular because anti-corruption fits into this kind of interest group that we speak. So I agree with you that I am not one for every single group that forms themselves or organize themselves to be appointed to a board. And I'm not in the habit of seeking to say which issue is more important to government. However, when I see anti-corruption as an area of expertise, I don't know if of that training. This seems to be an interest group that you're saying should be on it.
So what I'm going to do, I'm going to ask Senator Skeffrey to just phrase the proposed amendment. So members, would you please listen to the proposed? Members, please listen to the proposed amendment from Senator Skeffrey.
We are saying the minister, in his discretion, will nominate these persons. Or we are saying that the ministers will look at persons, in his opinion, that will not just represent a particular interest, but the broad interest of human rights. And if you have the minister having that authority, then I don't give the minister that authority to so determine. And we are saying that human rights is not important to the very nature of what we are saying. So at the fourth heading, and give the minister that discretion.
Senator Skeffrey is proposing an amendment to add a fourth category of person drawn from with the skill set of human rights advocacy. Correct? Beautiful. So I'm going to put that amendment. Those in favor? Against? Okay. Okay. Senator Brown, you all remember, I get into you. I get into you now. Because I have Senator Brown's. You remember Senator Brown's amendment, members? Senator Brown's amendment, which is being proposed, that deals with an issue that it's the same amendment that he had put for earlier clause. Remind me again, Senator Brown, where it is? Yes, 31.5, an amendment to 31.5. No, okay, you have something different? I thought it was different. Go ahead then, go ahead.
Yes, as it relates to the same clause, I'm proposing that we remove the constraints that the minister nominate two persons. I don't understand why it is necessary for us to say two persons from A, B, C, or D.
You want to propose a motion, you want to propose the removal of the categories completely.
Of the categories.
Those in favor?
Aye, over this.
Against? Okay. Senator Brown, no. Senator Brown, just restate it for me again. It was a similar amendment.
As was put.
I'd made a note of it. So
essentially what you're saying, that within 5 years I've been in the Senate.
Right, okay. So, yeah. Within 5 years, the person should not be eligible if the person within 5 years had sat in the Senate, House, or municipality, or in fact run as a candidate to any of these organizations. Those in favor? Those in favor? Aye. Against? No. Okay. So I put now section, so I put the amendments to, where am I, 30? The amendments to, yes, okay. The amendments to 32. Those in favor? Aye. Against? I put 32 as amended. I am at 33, and there is an amendment to 33, the deletion of paragraph D. Those in favor of the amendment? Those in favor of the amendment? Aye. Against? Ayes have it. I put clause 33 as amended. Those in favor? Aye. Against? Ayes have it. I am at clause 34, which is the amendment is contained on page 5 of the amendment sheet, and I put the amendment. Those in favor? Aye. Against? Ayes have it. I put clause 34 as amended. Those in favor? Aye. Against? The ayes have it. Clause 35. There are no amendments on the sheet relative to this, so I put clause 35. Those in favor? Aye. Against? The ayes have it. There are amendments significant to clause 36. Minister, you want to address them briefly?
The amendment to clause 36B, Mr. Chairman, based on the belief that it was improper for the committee which was conducting the investigation into the officers and operation of the agency generally to affecting its discipline. And so
okay.
Yes, that's the...
So I put the amendments to clause 36. Those in... Sorry, go ahead, Senator Brown.
At the existing B, I'm not sure if you're changing it. There seems to be a typo. The an officer.
Where is that, Senator Brown?
In line 3 from the top. No, it says the.
Where are you?
Line 3, performance of duty. The an officer. One of them articles need to.
Yeah, that paragraph has been deleted.
You're deleting B totally?
Yes. And substitute,
right,
yes.
Cool.
Yes,
yes.
So I put the amendment to clause 36. Those in favor?
Aye.
Against? The ayes have it. I put clause 36 as amended. Those in favor?
Aye.
The ayes have it. Clause 37.
And 38, Mr. Chairman. No
and
amendments.
38, there are no amendments to those clauses, and I put them together, if you don't mind. Those in favor?
Aye.
Against? The ayes have it. Clause 39, Minister.
Yes, in clause 39, Mr. President, we have, Mr. Chairman, we have deletions which also resulted from some concerns raised regarding the criminalizing of matters which could properly be treated by oversight committee or by disciplinary proceedings. And so that paragraph has been deleted.
Thank you very much. So I put the amendment to clause 39. Those in favor?
Mr.
Aye.
Sorry.
It's not for any amendment. I'm just seeking some clarification in respect to 39D and E, where it speaks about knowingly making false declaration or false statement of a material nature in any information provided to an officer, as well as in, sorry, it's D and the E which speaks about furnishing information which may be false or misleading. So, for example, Mr. Chairman, if one is compiling a dossier to provide the information, and it contains information like what I saw in the media, where one check was written at a particular municipal corporation, which was done without prior approval, and that report, that publication is placed in a dossier that is provided to the officer. But then it turns out that there are 112 checks that were signed without approval and without proper documentation. Would that constitute an offense?
That would be my understanding.
It would amount to an offense.
Yes. Well, what you described a while ago is a criminal act. It's a nature of corruption. This is why we have this bill, to scourge it out of the country.
The amendment, clause 39.
It may have an, but Mr. But
Chair.
At least what I appreciate with your comment is that you see where it is going, because it may require the resignation of a mayor. It may require the resignation of the mayor. Don't worry yourself.
Chairman, based on the legal advice. Based on the legal advice provided to us by Senator Charles, it definitely suggests that the mayor of Manchester should resign.
Okay, thank you very much.
Mr. President, no, Chairman, that's not how we do it. Chairman, today in the Observer, there's an article criticizing abuse of privilege by a minister in the Senate. and I'm suggesting, as exuberant as my friends are, if a matter is on its way to the court, they should the standing order requires that you treat it with a certain way, and I think that it's an abuse.
Senator Brown,
it's an abuse.
Nobody has been charged.
Senator Brown, Senator Brown, I agree with you, but if you did leave the ball alone, it would you never had to play it.
I want them to be able to say that you disagree with Senator Samuda.
But saying that somebody has been charged, Mr. Chairman, is not the case. I'm not aware of the mayor of Mandeville being charged.
I put the amendment to clause 39. Those in favor? Those in favor? Against? Ayes have it. I put clause 39 as amended. Those in favor? Against? The ayes have it.
There are no proposed amendments.
40 to where?
40 up to 43, Mr. Chairman.
Okay. I put clauses 40, 41, and 42. Those in favor?
43 as well.
And 43.
Yes.
Those in favor?
Aye.
Against? The ayes have it. I'm at clause 44.
There is a minor amendment to 44, which is listed on page 6, deletion of word, substitution of a word.
Thank you very much. So I put the...
Chair.
Yeah, 44.
44.3 as it is here. I note that there may be an omission, and I wish to point the minister to 44.3 says, an officer who is transferred and secondment pursuant to subsection 1 may be deployed in the public service on or before, and day referred to in section 1. I suspect it's the appointed day that is missing. And if it's at the penultimate, just after before, in 44.3, I suspect the appointed date might have been missing. And so I just asked them to check to see whether or not before the referred, yeah. So something is missing there, and they need to capture.
Minister, just let us deal with that, please.
Period. Thank you, Senator.
So I put the amendments to clause 44. Those in favor?
Aye.
Against? Ayes have it. I put clause 44 as amended.
You included period?
Yes, yes, sir.
Cool.
I put clause
45 and 46.
45 and 46. No amendments to those. Those in favor?
Aye.
Against? The ayes have it. Minister, before I get to the schedule, should I just... Ms. Gibson? Okay. So, Minister, there are...
Yes. Well, let's start with your permission, Chairman, clause 2.
Okay.
And I carry my colleagues to...
All right, so hang on. So I propose to recommit clause 2. Those in favor?
Aye.
Against? Okay, Minister, go ahead with respect to clause 2.
As it regards to clause 2, Mr. Chairman, we have...
Sorry, those are the amendments which are on the sheet now?
Yes.
Or were these done already?
No, this is an amendment which is listed on the new sheet, which was handed at the last sitting.
So we have an amendment to clause 2, which is contained on the, pardon?
It's contained, particular to section 4 of the Registration, Birth and Death Act.
Yeah, I see that.
Yes, that
so
was
I put
changed.
those amendments to clause 2. Those in favor?
Aye.
Against? The ayes have it. I put clause 2 as amended. Those in favor?
Aye.
Against? The ayes have it.
Clause
I
3.
propose the recommittal of clause what?
3. Clause 3.
But there's nothing on that on the sheet.
Well, I crave your indulgence. There's a matter. It's not on the sheet, but it was raised, I believe, by Senator Brown. And I would want to raise, because I did discuss it this morning, as regards to the operational independence. You recall that, Senator? Yes. And so whether or not sufficient is required for it to be deleted. Sufficient. For sufficient to be deleted, as it really adds no value.
Okay, so
to the concept.
section 3 is recommitted, and there is a proposed amendment to remove the word sufficient. Those in favor?
It's
against?
It adds nothing.
Against? So the ayes have it. I put clause 3 as amended. Thank you, Senator Skeffrey.
Yes.
No, man, we have no, Senator Skeffrey and I have no problem in that other place.
Also, there is clause 6, Mr. Chairman.
So clause 3, I put in clause 3 as amended. Those in favor?
Aye.
Good, excellent. Go ahead, Minister.
Clause 6, Mr. Chairman, in which you have simply inserted there the reference to the 7th schedule, which has been...
Okay, so those in favor of recommitting clause 6. Those in favor?
Aye.
Against? Ayes have it. Clause 6. There's amendment and amendment 2, which is on the sheet, page 1.
6.
Yes. Those in favor of the amendment?
That's a reference to the 7th schedule. Aye.
Against? Clause 6 as amended. Those in favor? Against? Ayes have it. It is proposed to recommit clause 7. Those in favor?
Aye.
Against? Ayes have it. Clause 7 is recommitted. Minister, there is an amendment.
Yes, as listed.
Those in favor of the amendment to clause 7?
Aye.
Those in favor of 7 as amended?
Aye.
Ayes have it. Clause 9. Those in favor of recommittal? Against? I put the amendment to clause 9, which has been recommitted. Those in favor?
Aye.
Against? Ayes have it. And actually, clause 12, did we deal with that? We dealt with that, right?
We dealt with clause 12.
But there are two things, yeah. So there were 3 clauses to be recommitted, we had noted, 29 and 30, but there was one before that. Can somebody help me? 12.
12.
Okay. So clause 12 is recommitted. Is it 12?
No, we had...
Why did I think that there were 3 clauses to be recommitted? 29, 30, and one more. Ms. Gibson, can you help me? 12. It's 12. We didn't take 12, you know.
I think we had also looked at clause 22, Mr. Chairman.
Pardon?
22.
Who was the other one?
Not
Okay.
12. We had treated with 12.
All right, so 22.
Yes, we took all of them.
May 22 be recommitted. You're perfectly right. May 22 be recommitted. Those in favor?
Aye.
Against?
But there's no need for amendment to 22.
So I think you were to, there was a question of the removal of 2, 3, and 4, and Senator Brown wanted some further clarification.
And I'm taking the minister's assurance that this clause, as it is, conforms with the financial requirement for government agencies to seek the permission of the Minister of Finance, the approval before loans. I take that.
Thank you very much. So I put the amendment to clause 22. Those in favor?
Aye.
Against? Ayes have it. I put 22 as amended. Those in favor?
Aye.
Against? Ayes have it. So we are 29 and 30. Minister, you were supposed to take some...
Yes. 29 and... I crave indulgence.
The timeline, yeah.
Yeah, sure. Go ahead. Sure. Go ahead. That's supposed to be for brochure, you know, not to pack the things a minute, you know.
Mr. Chairman, as it regards to section 29(3) to be repeated, and I know that that is also with reference to section 34, which is the other matter for recommitter.
No, it's careful.
No, 29(3).
29(3).
Yes, and what was the other one for recommitter?
Allow me 34.
34. So the two somewhat related.
Yeah. One is specific.
29 is a report which is not within the repose of the minister. That's a report he would be receiving, as it is in distinction to 30. And so I believe that what the basis of it was that we would want to give the minister an opportunity to be able to assimilate without having any time constraint for section 29. As in 30, you would have a greater role in it, and that is why there's a specificity of the time within which he's given to 1 month. So there's no need for us to have any amendments to either section 29(3) or 34. If you have, however, proposed amendments, put them.
No, but just seeking clarification with what you said. If you go to section 2, he has to receive the reports within no later than 4 months at the end of the financial year. So there's a time bound there. But after he gets it,
yes,
there's no time bound as to when he should report to Parliament.
Because we really can't dictate what he's going to get. And so I think what it is saying is we wouldn't want to tie the hands of the minister in the determination of how he would treat that report.
No, we're not tying the minister hand, but we're putting the minister on a certain timeline for efficiency and accountability to the people of the country.
What we could do is say a reasonable timeline.
So later than up, and then if he's not able to, then we can always seek extension from the Parliament, which is the people's representative.
We would not, in this case, be able to contemplate what exactly he's going to do. If you might, what we could do is introduce a wording, if it suits you, such as reasonable time.
But Minister, just think it through. If we are state agency, the civil servants must, at the end of within 4 months, at the end of the financial year, and all to present that report to the minister.
Yes. And
we are saying that, so we are saying the minister has an open-ended period which to analyze and table a report. So I'm saying within 3 months of receiving it or 2 months, I stand guided, but I'm saying it can't be this open that you say the civil servants, the state agency must report within 4 months at the end of the financial year. And then the minister will report to the people. He has no timeline in which to table this report. It's a table report in the Parliament.
Minister, you're suggesting that you would put the word reasonable?
We could put the word reasonable based on advice from the technical team as well. So if that could be sufficient, we could put the word reasonable, which would put not a specific timeline, but it would give at least some clear direction that it's not an open-ended situation for the
people. It's not sufficient, but I know you will vote me down, so I'll accept a reasonable word for consensus going forward.
All right, so the amendment would read, the minister shall cause a copy of, shall, within a reasonable time.
Yes.
Okay? So that's the amendment proposed. The minister shall, within a reasonable time, comma, cause a copy, etc. Those in favor?
Aye.
Against? Aye. Ayes have it. Section 29 as amended. Those in favor?
Aye.
Against? The ayes have it. So 30 no. It has been recommitted. 30 has been. Minister, you have something? What you had said about 30?
Well, I had indicated, Mr. Chairman, that further to advise.
No change to that?
There's change.
Okay, so I put section 30, clause 30.
The question I want for clarification. In the era of accountability, it applies very much to 29(3). What if the minister failed? What provisions are there in our system to ensure that the minister within a month? I mean, we have in the Senate, for example, Senator Charles, Senator Sinclair, provisions in standing orders for answers to be given in 21 days. That's not usually followed.
21 months.
So what I want to know is what action shall be taken against a minister who fails to deliver that report within the month that is required. Because too often, the Parliament, and in the past, there have been a lot of improvement. But for too often, we get reports very late, of very little value for understanding. For example, today we got a report for 2017-2018 from the Ministry of Science, Energy and Technology, a most current report. So I could look at issues like fence and wall and executive salary or part executive salary. I could look at it here.
Thank you, Senator Brown.
Yeah, my understanding, Senator Brown, and I appreciate the concern that you have, is that since it is a report that would be laid to the House of Representatives, Senate, it is the Parliament that would have the obligation and authority to treat with the absence of that report. The Parliament could deal with it.
Thank you very much. So I put I put clause 30. Those in favor? Against? Ayes have it. And we move to the schedules. And there is an amendment to the first schedule.
Yes, there's an amendment, significant amendment.
It is contained in the amendment sheet, and I put the amendment to the first schedule. Those in favor? I put the amendments. So we're dealing with the first schedule and the amendments there too. Any comment? Senator Brown?
All right.
Any other comment on
yes,
the...
Yes, on the first schedule. Minister, you would recall that after the last sitting, yeah, I just wanted the minister's attention because some matter had brought to his attention. Yeah, you finish? On page, draw your attention to clause 25 on page 33. You recall at E, Offense Against a Persons Act. You recall at after the last sitting, Minister, I brought to your attention setting fire to, it says ship. I suspect it ought to be shop. 30 what? At 25 on page 33. And I don't know if your technical people had a chance to look at to see whether or not it is setting fire to ship, etc., or setting fire to SHOP, shop. And it just maybe just a technical issue that I think we need to be clear, so we don't send this elsewhere saying ship when it should be shop, or if it is intended to.
Minister, the question is it ship or shop?
Or ship, sorry, with a P. So be careful. I don't want it to be said by all. We're checking. I believe it is ship.
It's a marine vessel.
Because it is what is already in the legislation. But it is, again, another reasonable question. But it's ship.
Okay, so I put the
shop would be under section 14, maybe.
So I put the amendment to schedule, the first schedule. Those in favor?
Mr. Chairman,
Sorry.
I just have a question for the Minister.
First schedule again?
First schedule.
Okay,
just a
so
general question.
go ahead, I'll put it again.
I wonder, Minister, because I'm just going through it and I see the different range of offenses, some more serious than others. And I just wonder whether there's going to be,
calendar,
in a very simple way, whether there's going to be any work left for the police force after this, because it seems to me that almost every offense, almost every offense is being deemed a major offense. For example, look at section, page 35.
Yes.
36 N.
35?
Yes. Right. 35, 36 N. Living on the earnings of a prostitute.
Section living on earnings
of a prostitute.
It's not a serious offense? Could not be connected to?
I don't know if it falls within the threshold of, for example, abduction of a child with intent to have sexual intercourse or forcible abduction. I don't know if it falls within the same category. I stand to be guided, but I wonder if it falls within the category. Just the clarification I'm seeking, sir.
Let me say this. There are several of the paragraphs that have been removed. After some significant and their calculated evaluation by the technical teams, looking on the paragraphs based on the concerns that were raised. In a very serious way, they have looked through, they have deleted several paragraphs, 1, 7, 11 paragraphs relating to agriculture, country fires, metal and jewelry. Anything that has been left here in Schedule 1 is left further to a determination by the officers who are from the technical team that it is connected to or required for them to advance the efforts of MOCA. Some of these things may very well not read immediately to be serious offenses based on your interpretation, but they can be connected to several things that are required for MOCA to achieve.
If I can just add,
their result.
Senator Fraser-Binns.
They've refined it, almost
Senator
half.
Fraser-Binns, I think that particular thing is a human trafficking issue.
Yes. Well, not only that, connected to that and more.
Anyway, okay, thank you very much for your intervention, Fraser.
Yes.
So I put the amendment to the first schedule. Those in favor?
Aye.
I put the first schedule as amended. Those in favor?
Aye.
Against? Ayes have it. I put the second schedule.
You
Those
could go
in
from
favor?
second to fourth.
Pardon?
Second to fourth.
Okay, second, third, and fourth schedules. Those in favor?
Aye.
Okay, schedules 2, 3, and 4. Those in favor?
Aye.
Against? The ayes have it. Senator 5. Senator Schedule 5.
Yes, Mr. Chairman, there's an amendment to Schedule 5 in that the reference to circuit court was removed for the offenses. All matters are tribal in the parish court, and so it was believed that it is a competent court to treat with the nature and seriousness of the reference offenses, and that was actually raised by Senator Knight at the last instant.
Thank you very much. So I put the amendment to Schedule 5.
Chair, in respect to the fifth schedule, we are concerned, as we have always been, to the practice, having deleted I withdraw. I was concerned about fine and imprisonment, but those are deleted.
Thank you, Senator Brown. So I put the amendments to this fifth schedule. Those in favor?
Aye.
Against? Ayes have it. I put the fifth schedule as amended. Those in favor?
Aye.
Against? Ayes have it. I put the sixth schedule. Those in favor?
Aye.
Ayes have it. I put the title and enacting clause. Those in favor?
There's the seventh schedule, very important seventh schedule, Mr. Chairman, which the powers conferred on
I'm sorry, this is a new schedule?
New schedule.
Sorry. just before you get there, Mr. President, Chair, and it's a typo in a sense, but on page 44, I just ask to reschedule at the 5th schedule. Under brief description.
So if I don't have to reschedule it, just bring it to the attention of the...
On page 44, with brief description of offenses, willfully making a statement to mislead or attempt to mislead the agency, the Director General. I suspect it's an AN officer as against ON. I don't know if you've seen it.
Thank you very much. You picked up that, people. Thank you very much, Senator Brown.
Yeah.
So the 7th schedule yes. is a new schedule.
It's a new schedule, Mr. Chairman, and it's a very important schedule which...
With MOCA and their operation so far, because I do recall, Mr. Chairman, that when they visited the Manchester Municipal Corporation and they took some computers. No, seriously, two former mayors, and one who sat in this parliament criticized MOCA and the numbers of officers that they thought they had to take.
Point of order, Mr. Chair. Point of order. The matter that the member is raising, I understand to be a matter in the courts of the country, and therefore it is improper under our in orders for the matter to be raised at this time.
Mr. Chairman.
Sorry.
Mr. Chairman.
Sorry.
Mr. Chairman. If I could quickly respond.
No, it's not for you to respond. It's for the chairman to respond.
No, he's to rule. The chairman is to rule, but I want to respond. I want to respond, Mr. Chairman.
Learned counsel who is addressing me, no doubt, is aware of that particular rule. I don't have to remind him, so let him continue.
I thank you, Mr. Chairman. And not only that, I'm not addressing the issue that is before the court. And the issues that are there are pertaining to a particular charge. I am speaking to an operation. And it can apply anywhere, because I do believe that these agencies, they must determine that when they go in, as they are expected to go in again, with the 112 checks that have been signed without proper documentation, Mr. Chairman, that they must determine the numbers, but critically what I see in the provision 32C, which allows for them to keep these computers or gadgets or anything they seize for a period until the determination of the matter or until the determination of the investigation. Those who hold these responsible offices and who sit in Parliament must not go on a public platform and criticize our state agencies for actions that they are properly taking. So I'm happy that this provision has been put here. We must give, if we are serious about what we are here contending, don't criticize them in their operations in respect to those frivolous things as to numbers of persons and what they may take as part of their investigation.
Very much. So,
Chair, justice is not a Christ virtue beyond criticism and so forth. I can't see any state agency. I'm not going as far as President Giuliani, but I can't see any state agency that is beyond the criticism of the elected or appointed representatives of the people. Okay, those who want to put that view may wish to live in a dictatorship. I don't, and we on this side have no such interest in a dictatorial.
Is that a new section, a new schedule 7B incorporated the legislation. Those in favor?
Aye.
Against? Ayes have it. And I now ask for the approval of clause 7. In favor?
Aye.
Against? Ayes have it. Schedule 7, sorry. Thank you very much.
Mr. Chairman, I just had to check the records just to see that we, at the last instance, it seems the at clause 8. And so just to be careful.
Schedule.
I'm going back.
schedule.
The last sitting, I had indicated, based on records, that we start at clause 12. And I'm saying to you, I check in the record.
Check to just ensure that.
I just want to be clear. So if we could, we dealt with 9 and we dealt with 10 and 11 today.
Yes.
Well, did we deal with 11? No. So just to be clear, you want us to go back to
well,
clause.
there's no harm in me putting it again.
Clause
if you have
8,
a question.
10 and 11.
Okay, so clauses.
There's no issues with it. Clause 8? Aye.
So I put clause 8, 10 and 11.
10 and 11.
Clause 8, 9,
8, 9, 10 and 11.
8, 9, 10 and 11. Those in favor?
Aye.
Against? The ayes have it. That's out of an abundance of caution.
Yes.
Thank you, Minister. So I now put the title and enacting clause. Those in favor?
Aye.
Against? The ayes have it. The question that I do report the bill as having passed committee stage with 77 amendments. Those in favor?
Aye.
Against? The ayes have it.
Good job.
I do report the bill as being passed committee stage with 77 amendments. May I just take the opportunity to thank all persons who participated in this debate in the civil and useful manner in which it was conducted, and I wish also to place on record I just wish to place on record as well the fact that the Minister did an excellent job in presenting the bill today.
Thank you.
Thank you very much. Thank you very much. Minister, third time. You're asking that the bill be read for a third time?
Yes, asking that it be read a third time, Mr. Right?
The question is that the bill be read for a third time. Those in favor? Against? The ayes have it.
A bill entitled An Act to Provide for the Establishment of an Agency of Government to be known as the Major Organized Crime and Anti-Corruption Agency to investigate and prosecute serious crime and matters thereto, read a third time and passed.
Mr. President, it is fitting that I acknowledge the conduct and the team effort of my colleagues in the passing of this legislation, one which is critical to the national security framework for our country. Mr. President, there's no further business to be carried out today, and so we ask that the Senate be postponed until the next sitting.
Mr. President?
My apologies.
Mr. President, on this motion of adjournment, I must say that hard work must be acknowledged and must be rewarded, and I use this opportunity to congratulate students all across Jamaica on their success ESAT examinations. And I'm sure that our colleague, Senator Reid, he would have preferred to be here to have done the honors. And the performance, Mr. President, I understand that it can only be described as staggering, as a significant number of our students got almost perfect scores. We congratulate their teachers, their parents, their family, the entire school family and the community. And let us continue to work hard so that our children can live in an environment that will have all the supporting tools and mechanisms that they need to grow. And students who may be disheartened that they were not placed at the school of their choice, we encourage them to work hard and that indeed they can be successful wherever they go. We continue to support our students who may be struggling, and we will put all the necessary support that they will need to come up to par. I'm certain that there are senators here like Senator Don Webby. You are excited about encouraging going down to St. George's College. I'm certain, I don't know who will be heading off to Campion, who will be going off to St. Jago High School, who will be going to Cornwall and Calabar and Glenmuir and Ardennes and Charlemont and all those schools. We especially thank our teachers, Mr. President.
Thank you.
We thank our teachers. We commend our teachers. Congratulations to all students across Jamaica. Thank you.
Indication that Senator was going to speak, I would have indicated to you so you could have responded appropriately. But if you wish, you may respond. You may respond if you wish. Senator Skeffrey.
Mr. President, let me, too, on behalf of the opposition, congratulate the many students, parents, teachers, and other critical stakeholders that continue to support, no parents, teachers, students, and other stakeholders, support our students as they prepared for the exams and also to prepare them for the results. Because many times it's after the exam that anxiety during that period sometimes can be very, very difficult for our students. Let me say all the students who have been placed in a school of their choice, and we have to understand what we mean by choice, because they actually have 7 choices. So sometimes there's a misinterpretation when we say the choice, because sometimes it's not their first choice, or even the third, because they have 7 choices, and when we say 80% have gotten a choice is really from that group of 7. So I want to put it in context, because sometimes I set up information out there. Also, let us ensure that we continue to upgrade our secondary schools. The disparity that still exists at the secondary level is what creates that fear and anxiety. We don't have many, we have 45 so-called traditional schools, and then what we call upgraded schools are technical schools. And the reality, Mr. President, while many fight for those 45 places, because in terms of science education, for example, if you don't have a good science lab, then you are at a great disadvantage. And many of our schools, despite the effort to upgrade, and I'm not dismissing that, we still are not reached where we want to go. Internet access in our classrooms is still a challenge. So as we prepare them from the primary school and integrate technology, we must also ensure that there's a smooth transition. And this notion of zoning that we are showing out there in the domain won't be accepted and won't be practical until we have parity across all schools. So whether you go to upgraded school or traditional school, if you want to be a civil engineer or doctor, the real opportunity presents itself. I know the decline in mathematics, though a marginal decline, and we know the importance of mathematics as creating the problem solving and critical thinking skills of our learners. So we need to commend the teachers, but encourage them to do more, and also to ensure that we provide the nutritional levels in our schools so the students can learn. And also give credit to some of those persons who have pioneered the policies. We are reaping some rewards today, but let's understand that in education, the reward is not something that is instant. So former Minister of Education, Ronald Twist, and his chief advisor, Dr. Johnston, have played a critical role in some of the rewards that we are earning here today. And we thank the current minister for continuing on that path, because when our students benefit, it's Jamaica benefit, and the progress will continue as we advance. I thank you, Mr. President.
Thank you very much. Thank you very much, Senator Skeffrey. May I just before we adjourn, just bring your attention to the technical persons from the various agencies who are with us today, and ask the minister to convey our gratitude to them. Thank you very much. The question is that the Senate be adjourned for a date to be fixed. Those in favor? Against?